Hey there, I'm estate planning attorney Paul Rabalais, and in this video, we're going to talk about the difference between a living will and a last will. All right, so many terms in estate planning that people confuse them often. Some people kind of mistakenly believe that getting a will and estate planning is exactly the same thing, but estate planning is a much broader term of assessing what's most important to you and who is most important to you, and then developing a strategy and implementing that strategy so that what you have is protected, you're protected, and then also those most important to you are protected. So in this video though, I want to talk about the difference between a last will and a living will. And a lot of people tell me, make statements, and I want to just kind of cringe or correct them immediately. I hate correcting people too much, but they might tell me something like, Paul, I want a living will because I want my house to go to my son. And I'll kind of cringe when I hear that. I'm like, okay, I got to correct that. Or they might say, Paul, I want a will so that my daughter can have power of attorney. So all these terms, and I think what makes it confusing is that, if you look at the terms will and testament, living will, living trust, they all have that term either living or will in them, so everybody gets mixed up. But in this video, we're going to focus on two things, living will and last will. First, let's talk about living will. Problem with living will is not everybody calls it a living will. Some people call it a declaration or a living will declaration. The whole idea behind a living will is that during your lifetime, you get to make your medical decisions. That's well recognized as a fundamental right. You get to make your medical decisions. However, if you are on life support, how do you make that decision regarding whether to withhold or withdraw treatment if you're in that terminal and irrevocable condition? You're not going to have the capacity to make that decision on whether to withhold or withdraw treatment. So in advance of getting to that point, you can document your wishes in a living will, and those wishes that you document in your living will must be honored by your doctors and your family. Why they call it a living will, I don't know. I guess when this was created a couple of decades ago, somebody made up that term and it stuck. But living will, people perceive a will as something where you're giving assets away when you pass away, and then living will is some living component of that. But how that has to do with life support machines, so it may not be appropriately named, but it is what it is. So many people perceive a living will as something that enables you to relieve those closest to you from having to make that difficult decision to terminate life when there's no hope for recovery and the machines are just artificially prolonging the dying process. So that living will or that living will declaration is typically expressed something like, if I'm in that profound vegetative state and there's no chance of recovery, and two doctors, perhaps the document states that one of those doctors must be your attending physician, have certified in writing that you're in that vegetative state and there's no reasonable chance of recovery, and that the machines are serving only to artificially prolong the dying process, then what your living will does under all of those circumstances is, what it typically does is it's where you direct that those machines must be withheld or withdrawn, but that you have enough medication to remain comfortable. So you can deviate from that somewhat, but that's the gist behind the living will. Okay, now let's move to the last will. We just covered the living will, now the last will. Both have the word will in them, two-word phrase, both have the word will as the second word of that two-word phrase. Now let's talk about last will, also referred to just as will or last will and testament. Now that's something that you create now, but it doesn't take effect until you pass away. So most common things that are accomplished with your will / last will and testament are you get to decide who gets your stuff. And you can be specific if you want to. When I pass away, I leave my house to my son. You could be general. I leave my estate to be divided between my 3 children equally, or I leave my estate to be divided among these 5 people in these proportions. Or you can be both specific and general. I leave $100,000 to my grandson, and I leave everything else that I own when I pass away to my children equally. Also in that will, you name your executor. That's the person in charge of making sure everybody gets what they're supposed to get. They don't get to exercise any discretion to shift, how things go. They're just the people in charge of hiring the attorneys and guiding the family through the court process. Also in your will, you can leave things to a trust. So I said a moment ago, somebody might say I leave $100,000 to my grandson, everything else to my 3 children equally, but that grandson may be 14 years old. So in your will, you can say I leave it to a trust for my grandson. It can be used for his education. If he goes to college, great, it can be used for that. And then when he's 25, he can get half of what's left. When he's 30, he gets the rest. So you can leave things to a trust in your will. And then if you have minor children, or maybe expect to have them in the future, you can name those guardians, or also, referred to as those backup parents who can raise your children if you pass away before your children reach the age of majority. So 2 very different things, living will, last will. Hope you're starting to understand the differences. You'll sound and look really intelligent if you can kind of nail the lingo here as you have these conversations with people throughout your lifetime. Okay, have a great day. We'll see you next time. Make sure you like and subscribe.